talk about today is how state court judges are selected, what are some of the problems that have arisen in the last couple of decades in that area, and why people should care, why all of you should care, and also what are some policy solutions in that area. I'd like for us to just go ahead and jump into things here. Let me just briefly introduce the speakers. Bert Brandenburg is the Executive Director of Justice at Stake, which is the leading organization in the country based here in Washington that advocates for fair and impartial courts. Alicia Bannon is the head of the state court program at the Brennan Center. Alan Morrison needs no introduction most places, certainly not in this room. But Alan, in a very distinguished career, has litigated in all kinds of courts, state and federal. And so we really welcome today his perspective as a litigating lawyer and on why state courts matter. So to get us started, Bert, could you, your organization, as I said, advocates for fair and impartial courts. Can you give us an overview of the state court system, the leading selection methods, and where things stand right now? And I actually should also say, Bert and Alicia was the lead author, Justice at Stake, also heavily involved in the new politics of judicial selection, which which I think there will be copies available. They're headed this way, which is something that Brennan, the Brennan Center and Justice at Stake do every election cycle, and is pretty deep dive into what is going on. So that will inform a lot of our conversation today. Bert?
All right. Thanks, David, and hi, everybody, and thank you for coming. As David said, this is an issue that isn't covered in law school by itself. I certainly learned nothing about this. We all read state court cases and yet are given very little exposure traditionally to the state courts as systems, unless you take specialized courses. And frankly, a lot of what we're going to hear about today has been changing rather rapidly anyway. So it's a very good time to be on top of this topic. I hope you'll agree by the end of the session that it's really a topic worth paying attention to no matter where you go in your careers. Because it is, as David was sort of getting to, we sometimes talk about it as the biggest democracy issue that nobody's ever heard of. It's flying under the radar. We all know our democracy faces a lot of challenges. The political system is under a lot of stress. What's not very well known is how that's spilling over into our state court system. We're going to talk about one aspect of that today. I will mention there were many dimensions to it. You can talk about attacks on federal jurisdiction. You can talk about impeachment threats against judges over decisions. You can talk about attempts to cut their funding. We're going to focus instead today on what's been going on in judicial elections, particularly judicial elections. And the answer is quite a lot, but to set the table, as David asked, it's worth stepping back and thinking for a minute about how we choose our state court judges. There's a bit of an interesting history there that gets us up to today, but it's first worth noting 98% of all court cases in America are state court cases. The federal judiciary gets the vast majority of attention, but it's the state courts that are, they're simply, essentially the engines of justice. They are what justice is to most people most of the time in the United States, and that's not going to change. That's the way the system's built. So therefore, even though they don't get as much high-profile attention, who goes on the bench, and in addition to how the court system is structured, who our judges are is hugely important. Not only what their backgrounds are, how qualified they are, how good they are at the job, but also the pressures they face when they're on the bench. They're supposed to deliver fair and impartial justice. And when the United States became its own country, the 13 original states pretty much picked systems that kind of mirrored what the federal government was doing. It was variations of appointment and confirmation. And the real change began with Andrew Jackson. As populism came in, there was a widespread perception that picking of judges was a corrupt insider's game, that it was buddies of legislators, that it was complete cronyism, and had to be cleaned up. And how do you clean that up under populism? Let's elect the judges. Let's give power to the people. Let's help them. Let's let them help clean up the system. Let's take it away from the insiders. And so as a result, every state since then, pretty much most of the states, adopted variations of judicial elections for large parts, if not all, of their judges. And to sort of fast forward even further, we're at a point now where it's quite frequent for different levels of judiciary to have different selection systems within a given state. So state X might do elections to the Supreme Court and appointments for the middle court and merit selection or whatever. But we're at a point because of historical trends and states being their own laboratories of democracy where it's a complete patchwork. No two states have the exact same system when you take into account those various levels of the courts and when you take into account length of term. No two states have the exact same system. The major trends along the way have been essentially two or three. You had the impulse, as I said earlier, populism to go to judicial elections. Most states wrote that into their constitution. And yet, after a number of decades of that, there was a feeling by the turn of the beginning of the 20th century that system was being overtaken by party bosses. And again, too much insider power was created. And so how do you deal with that? At that point, as an alternative to contested judicial elections, you had what's called a merit selection and retention election system arise. And the idea there was to try to create essentially a hybrid. You would have on the front end, instead of a direct contested election, you would have a screening committee of people who would help come up with a slate of candidates, hopefully good ones, that the governor would then pick from. And so the governor would not have unfettered choice to pick a crony or a roommate from college, but at the same time, they would pick from a slate that hopefully had quality judges. That person would then go on the bench, serve for some number of years, and then stand periodically, typically what's called a retention election, which is instead of having an opponent, you stand by yourself. So when you're a voter, you go and you decide to keep the person or not. If you keep them, they stay on for another term. If not, you start the process over again, you leave the bench, and you go back to a selection committee. That merit selection system, as I said, was designed to try to make the system less political, knowing that no system can reduce politics altogether or eliminate them rather. And in fact, it was adopted over the course of the 20th century over a number of decades by more than a dozen different states. And we're at a point now when you look at just the simple systems themselves, where, as I said, we have a patchwork. I think for the purpose of most of the discussion, at the Supreme Court level, that's where we have most of the data. These issues, definitely affect the other courts. But if you look at Supreme Courts in the United States, 39 states, Supreme Court justices have to stand for election during their career, either in one of these competitive races or a retention race. I think it's 22 of those have competitive election for the high courts, the other 17 have the retention races. Once you get on the states, to break that down even further, there are a bunch of states where the competitive elections are partisan, where you go in with a party label, and there are a number that are not. I think it's like 7 and 15, but that actually shifted a little bit in the last few years. So you can start to see the variation. You can start to see how state political cultures have affected not only judicial politics, but how the judges are picked themselves. And hopefully you can start to think a little bit about what it means for the pressures the judges are under once they get on the bench. Because that essentially is what brings our story forward to the development we're going to talk about, and Alicia in particular is going to detail. Essentially, for this time period, over 150 years, judicial selection, under whatever system, was not really paid attention to by a large degree of people. Turnout in these races weren't necessarily terribly high, and also the money, and the sort of crazy part of politics, didn't typically affect these races. They were most often a bit sleepier than the rest of politics, with occasional exceptions, and those exceptions even continued through the last few decades. So you have in the 70s Rose Bert and another California Supreme Court justice, which also defeated over their decisions, not only in the death penalty case, there were a number of coalitions that came after them. You had Penny White in Tennessee taken off the bench a number of years ago. But merit selection systems have largely been far less prone to big money influence, and the sort of big bang was 2000. We saw in the 1990s a couple of states where there were concerted efforts on the part of consultants to put together, in Texas and Alabama, efforts to essentially flip a state court bench much more systematically than ever been done before. And actually, the consultant by the name of Carl Rove were helping these efforts in Texas. And then in 2000, we saw this really start to grow more nationwide. We saw a number of states at the same time suddenly a lot more money. And the money Alicia's going to get into was essentially for more money. So you have the chambers of commerce, the business groups, duking it out against unions and plaintiffs' attorneys. we really began to see that spread around the country. So as we sort of fast forward to the present day, we now have a system that on paper has not really changed that much. I mean, we haven't seen a state change its system to pick judges in a few decades. That sort of spasm for the moment played out. There are other efforts periodically. What is really, however, changing in a hurry is what goes on in those elections themselves. And the pressures of the judges who signed up for one system are now feeling that the system changes under their feet.
Thank you, Bert. So, Alan, as Bert said, the formal structures of judicial selection in most states have not changed in the last couple of decades, although the system as a whole, as a practical matter, has changed greatly. And one of the things that's helped bring about that change is a couple of Supreme Court decisions that, one of which was directly about judicial selection, and one of which was not, have reshaped the terrain. Could you explain how Citizens United, the case which did not directly deal with judicial selection, and Republican Party of Minnesota versus White have given rise to the system we have today?
Sure. First, wonderful to see so many people here. Thank you, ACS, for bringing everybody out and giving us food as well. I'm sure that had nothing to do with anybody besides the panelists, who at least got something to eat. Let me just say a couple. First, state courts are so different in so many ways that even the highest court in the state is not always the Supreme Court. For those of you who are going to New York, the lowest court in the state is called the Supreme Court, and the highest court is called the Court of Appeals. They do this so you have to figure, it's harder to figure out what's going on. Second, California has a system, in theory, in which everybody gets elected. In fact, in California, nobody gets elected, at least to the court initially, because there's a history of strategic resignations that people resign so the governor can appoint your successor, and then you run for election against nobody, and almost everybody wins. So as Bert said, the systems are very different. We once litigated before, a long time ago, we litigated a case involving judge selection in Texas, and the first thing we found out was that, among other things, judges ran for election, and the trial judges ran every 4 years, which is really a short period of time, particularly for trial judges. And guess who supplied all the money for trial judges, most of which were for criminal cases? The DAs and the assistant DAs. And the defendants didn't have much of a pack to supply the money, and so you've got very pro enforcement judges in that court. I have a friend who told me this wonderful story about, he's a lawyer from California who was litigating a case in Texas, and at the recess, the judge said to all the lawyers, out in open court, it wasn't part of the proceedings, but he said, now you all coming to my fundraising barbecue this evening? He said, the lawyers were appearing before him in the case right then. And the lawyer from California didn't know what to do. He didn't know what to say. So he talked to the lawyer on the other side and said to him, I'm not sure that I can do this because California's got some pretty strict rules about this, and I don't know whether they would apply in this case or not. And so maybe we could both agree not to go to the barbecue this evening. And so they went to the judge and they said, Your Honor, since I'm from California, I'm not sure that my bar would let me do this. I know it's perfectly legal in Texas. Texas actually is the only state in the country that allows judges to personally solicit anybody they want for contributions. It's got an express exception. The ABA rule says no personal solicitation. No, not in Texas. Okay. And they said, Your Honor, we both agreed that because of this, I won't come. My adversaries agreed he won't come either. Judge, that's all right. You all won't miss my barbecue this evening. That's fine with me. So you have a different culture there in what's going on in Texas. The other things about judicial elections that are really important, and when I taught ethics, I in fact did put a unit on this in the class to talk about judicial elections. And one of the questions is, what are judicial elections supposed to be about? What are you voting for? And does anybody have any information about any of these people? I mean, yes, you could tell, I want to be a judge. I graduated from law school 2 years ago. Maybe you could say, okay, but that's not the people who are running for office, or I've never tried a case, but I think I'd like to be a trial judge. No. And how do we get information out about the people, and how can lay people who make up most of the voters judge them? And what are we supposed to be determining this on? Do we like their philosophy? Do we understand what that means? Do we like their outcome? Moreover, these elections tend to be down at the bottom of the ballot, which means that there's a huge drop-off in participation. Even I heard once in Michigan for the state Supreme Court, they were down at the bottom of the ballot below the county dog catcher because that's the way they did it in Michigan. So it's a really serious problem about what elections are about. So the first case is called Republican Party against White. And this was a case brought to challenge the law in Minnesota, which was the law in most states at the time, that candidates for judicial office could not announce their views about any matter that might come before them. Now, the Supreme Court, by a vote of 5-4, joined by Justice O'Connor, who has subsequently expressed some misgivings about that vote, said that the rule violated the First Amendment. The court said, look, if the state is going to have elections, you've got to let people talk and exercise their First Amendment rights to do that. I'm not sure I agree with the constitutional analysis, but I do think there's something to be said about the notion that if you're going to let people run for office, we ought to at least be able to ask them some questions and give some answers. And of course, one of the problems is that the people with the money, the people who are supporting these candidates, they know what the candidate is going to do or what they think the candidate is going to do. They don't have to be told, they don't have to have anybody announce their opinions about it. And so the question was, should we have a game called Let's Pretend? Let's pretend this is about something else that it's not. Because it's really about what you think the outcome is going to be. And you see this in many judicial elections where the money is coming in to argue, as in the Penny White case, about what Penny White was doing in the criminal law system. That's the cover for it. But most of the money is not coming from prosecutors because they don't have a lot of money. The money is coming from people who worry what they're going to do with tort, contract, class action, what they're going to do about the rules of procedure that make so much difference. Those are the things they're worried about, but that's not what the publicity is about. So it's all a gigantic cover, and so disclosure is really important so you know where this money is coming from. And much of it comes from out of state for perfectly understandable reasons. If you're a national corporation and you're doing business in Ohio, there's a lot of big cases in Ohio that you're going to want to worry about, so you're going to want to put your money in. And so while I think that some of the fears in Republican Party against White, that people would be pre-committing, that they would be promising to do things they shouldn't be doing, I don't think those have materialized. There's very little of that. And what has been there was there before, just we didn't know about it. So I think on balance it's all right. And by the way, I can't very much change my mind because I wrote a law review article in the email. Law review it says that. So I mean, I've changed my mind, but I'm on record on that, and I haven't changed my mind. Citizens United, which was of course not about judicial elections, although there was an earlier case a couple of years before about judicial elections in North Carolina, and everybody wanted it not to be on the calendar. And my own view was that's the best case, that we would have stood a better chance if Citizens United had been about judicial elections than if it had been about elections for president with not such terrible facts in it. But I think that the big thing is judicial elections. And it's not contributions, it's independent expenditures. Many states have had laws allowing them in the past, but I think what the court has done is given an imprimatur. It's okay to spend money, and you don't have to deal with your shareholders. Indeed, if one had to deal with one's shareholders on this, you could say to them, listen, this is really a good investment. This is exactly why we're spending. This is much better money than we spend on our lobbyists and on our political, on our other advertising, because we only have to get 4 out of the 7, and they depend on the outcome of the cases. So it's really a good use, and you should be happy we're spending our money on this. And as an overall political matter, they said, well, we have a First Amendment right. The Supreme Court has upheld it. Unfortunately, there's not much that can be done about it. The court has closed off virtually all the other avenues, state funding of elections. Yes, they can do that, but the court has been absolutely clear that you can't stop outside groups from making their own political contributions and independent expenditures. And so we're in a bad way on this. And state courts really do matter. The action is, despite what we don't talk about in law school. That's the way that's what's going on. So it's something we all need to think about and worry about.
Bert and Alicia, any thoughts about why or Citizens United? Build on what Alice said.
Sure. Well, to just say something more about Citizens United, I think you're absolutely right about it creating a sort of judicial imprimatur for independent expenditures. I think it also helps create a spending infrastructure on the federal level that now is also bleeding into state judicial races. So, we started to see, so-called social welfare organizations like Americans for Prosperity, which have, gained increased prominence post Citizens United, and principally in the federal level, have also started spending money on state judicial races. So, Americans for Prosperity spent money in Florida and North Carolina in 2012 in their Supreme Court elections. So I think we're starting to see, so those organizations that I think were in response to the federal decision and perhaps were initially focused on influencing federal elections are also now turning their sights to state courts.
I'll just add a little bit about white, because a number of us, our organization filed a brief, and a lot of us were very worried. The day the decision came down, the head of the ABA said, this opens Pandora's box. And I'm not sure that's exactly what happened on the terms people were saying at that moment. It didn't turn into enormous number of judges suddenly making far more outspoken statements than they had before, essentially making promises of the kind you never want a judge to make. However, I think its cumulative impact, particularly when you connect it to Citizens United, a lot of the other jurisprudence that's just pouring more money into the system, is perhaps even more dangerous, because it essentially starts to reinforce in terms of what the new system is in judges' minds, because in the end, judging is something you do in your mind. And there's only so much we can sort of measure from the outside. And the more you tell a judicial candidate that, some combination of a little bit of what you say to the right people, perhaps in public, combined with what you know will happen on the money side, whether or not you ask for that money yourself, you have more judges essentially looking over their shoulder as they're doing their jobs. And it's really been this, I think in many ways, a combination of these things all coming together that's now sending signals to judges about the pressures, and I think we all fear as well, signals to people who are thinking about even going on the bench. Number one, whether they want to get into it if they don't feel like being a big money person. And number two, if they love that life, that's what politics is about. Maybe they find the judiciary more attractive and would rather run for Congress.
Okay, well, so I think that gives us an overview, right? We've heard about a system, a patchwork system that evolved slowly over time, different situations in every state, but that in the last 15 years has changed greatly in almost all in one direction. More money, more politics coming into state court races. So Alicia, you really drilled down for the New Politics report into what went on in the election, the state court elections of the 2012 cycle. Can you give us some of those details?
Sure. So, as we were talking about, starting in 2000, we really have started to see, arms race spending around these state judicial races. Business interests on one side, trial lawyers, unions on the other side, started increasingly to pour money into state judicial elections. Realizing that this is a tremendously, state courts are a tremendously powerful institution for, shaping policy and for, determining their interests. And so, starting in 2000, we really started to see, notably higher levels of spending on these races, and these races becoming increasingly politicized. And one of the things we found in 2011, 2012 is sort of more of the same. We're continuing to see special interest groups pouring money into, we were specifically looking at state Supreme Court elections, seeing interest groups pouring money into those state Supreme Court elections, trying to shape who gets chosen, and trying to shape the decisions that judges are making. We saw, for example, more than half of the campaign contributions in 2011 to 2012 came from lawyers, lobbyists, and business interests. So some of the people and groups who are going to be directly appearing before the judges that they're contributing money to, and we think that's a very, very disturbing trend. We also saw that the top 10 spenders nationally were responsible for 35% of spending nationwide. So we're seeing a real concentration of spending power with a few groups. So that's sort of the more of the same that we've been seeing. There were also some new trends that we saw in 2011, 2012. One of the most significant was the rise of independent expenditures by parties and special interest groups. So I have a slide. It's over there, so hopefully you can see. I mean, basically what we found was record levels of, if you look at overall spending, it stayed roughly, it's high, but has been high over the past decade. But if you look at the portion of that spending that is made up of independent expenditures, that's really exploded in 2011 to 2012. About 43% of all of the spending that went on in that election came from independent expenditures, according to our estimates. And that's significant for a few reasons. First off, I think it's partly due to a Citizens United effect. As I was saying before, one of the things that I think happened as a result of Citizens United is both sort of a judicial imprimatur on this kind of independent expenditures, and also the creation of more spending infrastructure for independent groups to start trying to influence races. And that spending infrastructure is now being applied to state judicial elections. So why does this matter? Why might we be more concerned about independent expenditures versus other kinds of spending in Supreme Court races? I think there's a few reasons. First off, due to weak disclosure laws in a lot of states, it can be particularly hard to figure out where that money is coming from. So as compared to campaign contributions where there's typically more transparency. So it contributes to, so from the perspective of allowing voters to be informed about who's trying to shape their courts and in the spirit of transparency and disclosure, that's one reason for us to be concerned. A second reason is that what we found, one of the things we do in our report is look at television advertisements, and I'm going to show you a few in a few minutes. And we analyzed, for example, negativity in those advertisements and found that on the whole, particularly special interest groups are much more likely to go negative than candidates who are making ads themselves. And if you think about it, it probably makes sense. There's a little bit more distance. If an independent group is putting out an ad, there's a little more distance between that group and the candidate. And so, they're more likely to go negative. They're more likely to go mudslinging. And so if we're concerned about the increased politicization of these races and sort of a race to the bottom in terms of attack ads, this trend is also troubling from that dimension. So that was one big change. Another big change was just the total amount of TV spending was higher than we'd ever seen before. We started tracking, this is the 2011-2012 report, but we've been looking at this issue for over a decade. We started first tracking television spending in 2000. And the television spending we saw in this most recent cycle is higher than we'd ever seen before, even adjusting for inflation. So that's another significant, something that's new about what we're seeing in this most recent cycle. I think part of it is that TV is increasingly becoming how Supreme Court battles are fought in many states. It's becoming more important as a tool. It was more, so like I said, we saw unprecedented levels. It was more than $33 million spent in that 2-year cycle. I think also there's perhaps also a bit of a Citizens United effect here in that because there was just in general a lot of television spending that went on, particularly in the 2012 race, I think that ratcheted up just ad prices around the country as well. And so, for people who were seeking to spend money then on state Supreme Court races, they were just facing more expenses to start with. So I think that's another reason why we were seeing such high levels of television spending. Another finding in our report is that mudslinging has really become the new normal in a lot of states. So we documented 10 states where negative advertisements aired. So that was 10 of the 17 states that we documented advertisements at all. And we found this to be a troubling trend as well. blurs the lines between politics and judges. You start politics and judging, you start to think of, we start to think of judges as politicians and rogues if they're having attack ads just like you see in an ordinary political context. Another troubling aspect of this is that the ads are frequently misleading. So you're starting with races that are already incredibly low information, as we were talking about before, and then you add in misinformation about candidates' records and the decisions that they've made. So rather than increasing voter information, you're actually further muddying the water in a lot of these cases. And then finally, a number of these ads specifically focus on decisions that judges made on the bench, which I think is particularly troubling because it essentially sends a message to judges that if you make an unpopular decision or a controversial decision, you're putting yourself up for a potential attack for the very content of your decision, which I think raises specific due process concerns. That judges are going to be sitting on the bench worried about how a decision they're going to make is going to be then utilized in an attack ad, going forward. And so with that, I thought I wanted to show you just a couple of examples of some of the television advertisements that we were able to document in the 2011 to 2012 cycle. And you have to bear with me a little bit because I'm hoping that this AV equipment will work. I'm given instructions, so.
June 16th, 2010, the day our life was shattered. My son Joe was taken from me, killed when his team was attacked by terrorists in Afghanistan. My son selflessly gave his life for this country. But when I heard Bridget McCormick volunteered to represent and help free suspected terrorists, I couldn't believe it. My son's a hero and fought to protect us. Bridget McCormick volunteered to help free a terrorist. How could she?
So that's one ad that was broadcast this year, 2012, in the Michigan Supreme Court contest. The ad came from the Judicial Crisis Network, which is a DC-based group. So, another trend that we saw in this most recent cycle was national groups weighing in on state races, national politics coming into state races. And so this is one example of a Washington, D.C.-based group that was trying to shape the outcome of the Michigan Supreme Court race. So they spent between $600,000 and $1 million to broadcast this ad. As you see, it features the mother of a Michigan soldier who was killed in Afghanistan, and it refers to one of the candidates, Bridget McCormick, her involvement as a volunteer co-counsel for Guantanamo Bay detainee. As a matter of fact, the detainee was transferred for prosecution in Tajikistan, where he's serving a 17-year term. So even the content of the ad is misleading. I'm not going to show videos for all of them, but I wanted to give show one more video, and I wanted to just give a couple other examples. So this was an ad that came out of Ohio in their 2012 race, where this was one that came from the Republican Party, who spent about $100,000 on this ad, and it accused one of the candidates, Bill O'Neill, of, quote, expressing sympathy for rapists. And this was a decision, this referred to a decision that Bill O'Neill made on the bench. It was an ineffective assistance of counsel case and a rape case, and as part of his decision, he spoke about the seriousness of a rape conviction, and the statements he made on the bench were then taken and distorted in this ad to suggest that he sympathized with rapists. The Ohio State Bar Association described the ad as misleading and stated that it, quote, impugns the integrity both of a candidate and of the court and implies that justice is for sale. Another ad, this came out of Wisconsin in 2011. This was from a progressive group, the Greater Wisconsin Committee, that spent $500,000. It referred to the sitting justice, David Prosser, his time as a district attorney, where they portrayed him as having covered up a child molestation case. And the quote from the ad says, "Tell David Prosser judges should protect their children, not sex offenders." And this was another ad that was criticized as misleading, including by the victim from this very case, who labeled the ad offensive and inaccurate and called for it to be taken down. And if they refused to do so, it continued to air. And then I'm going to show one more video.
Lee Parrish and Roger Wheeler were sentenced to death for ruthlessly murdering pregnant women. But former Justice Janet Stonebow voted to reverse both convictions. Not one of the other 6 justices agreed with Janet Stonebow when she wrote, "The trial court erred allowing the juries to hear evidence that the victims were pregnant." Former Justice Janet Stonebow sided with criminals 59% of the time. For fairness, re-elect Will T. Scott, Supreme Court Justice.
So this was an ad coming out of Kentucky, the Kentucky Supreme Court race. This one was by Justice Stonebow's opponent. So somewhat of an outlier in that, most of these ads, as you saw, came from outside groups or political parties. They're more likely to do attack ads, but candidates are also capable of doing attack ads themselves. This is a troubling ad because I think it has a racial dimension. There's sort of a Willie Horton style approach to this ad. It also distorts her record. There were some newspaper analyses after the fact looking at exactly how many times she actually quote unquote sided with criminals, and said that in addition to being troubling for the overtones of this ad, it also misrepresented her actual record on those issues. And this is another significant ad in that it focuses on criminal issues, and we see the Center for American Progress actually put out a really interesting report just a few weeks ago, specifically looking at the relationship between kind of criminal justices who are focused, or ads and other attacks that are focused on judges' records on criminal justice issues, and then the criminal justice decisions that judges are making on the bench. So basically finding that, not surprisingly, judges are getting the message. If they're being attacked for criminal decisions that they're making, that, at least on some level, is potentially influencing the actual decisions that judges are making. And what's really interesting as well, if you look specifically on criminal issues, and I think we were talking about this earlier, criminal attacks on justices' records on criminal justice issues are a very common kind of attack ad. Oftentimes, if you look at who's actually spending the money on those ads, it's not people with an interest in criminal justice issues, it's people with an interest in tort reform or other issues, but this is seen as a wedge issue. This is seen as something that can kind of get the public's ire, and so this is where people turn for attack ads, and it's troubling when you think then how judges are going to be approaching criminal justice questions going forward. And so this. And then I just wanted to conclude, I mentioned earlier that independent groups are more likely to go negative than candidates, and so we just have a graph that reflects that dynamic as well. So if you look at the percentage of positive ads by candidates, it's about 89% were positive, and only 11% were negative in some way, either attack ads or contrast ads. If you look at independent groups, more than half of all of the ads were either attack ads or contrast ads, so we're sort of negative in tone. So you see a big difference between how candidates are using television and how outside groups, and to a lesser extent political parties are. And so when we're seeing some of the changes in how money is actually being spent in these races, like I said, this is one area where, looking forward, you could potentially see a real transformation in the tenor of these races and a sort of race to the bottom as we see more negativity and more politicization as these outside groups are weighing in directly rather than contributing to candidates. And then very end, I'll just have a shameless plug. If you're interested in the New Politics Report, this is a website that has a copy of the report. And also, if you're particularly interested in the ads, we have a very useful searchable database where you can look for different, look by state, look by content. We have various codings of the ads. So, if anybody's looking to do a paper on Supreme Court television advertisements, this is your place to go.
Great, thanks, Alicia. Well, before we touch on a couple more things, and then get to your questions, I wanted to bring one additional element into the mix. which is another study that the American Constitution Society sponsored called Justice at Risk. And what Justice at Risk is an empirical analysis of campaign contributions and business and Supreme Court, state court, Supreme Court decisions. And I think, as I go through the findings here briefly, I think your reaction to most of these will be, well, yeah, sure, of course. But the point of the study is there are a lot of things that we think we know. The point of the study is to provide an empirical basis for saying that these things are in fact the case. So the key findings of the study are that so what the study did is it looked at business decisions, both because we needed to have some principled way to limit the universe of cases we look at. As we've said earlier, the state courts do a huge 98% of the business of the nation, so you can't look at all cases, so we needed a way to limit it to certain cases. And also because, as we talked about, independent expenditures have become a huge factor in elections. If you look at direct contributions to candidates, so people writing checks to judges, what you see is that business groups and the plaintiffs' bar, who have been the two historical, the two groups kind of battling it out for control of Supreme Courts, and direct contributions are basically equal between those two groups, but that the plaintiffs' bar makes almost no independent expenditures, whereas business groups make huge amounts of business expenditures, and that's what's really driving some of the charts we saw earlier. So we looked at, we wanted to look at the group that was having the greatest political impact on state Supreme Court elections. So what the study found was there is a statistical correlation between contributions to state Supreme Court justices and the voting of those justices in cases involving business matters. The more campaign contributions from business interests a justice receives, the more likely he or she is to vote for business litigants appearing before him. And the trend plays out until you get to the point where a justice who receives half of his or her contributions from business groups would be expected to vote in favor of business interests almost 2/3 of the time. Again, I mean, I guess that's common sense, right? If a judge has is able to attract half of his or her contributions from business interests, you would think they would have a pretty pro-business voting record, and so that's what you see. And then the other thing that was perhaps slightly less intuitive, there's a stronger relationship between business contributions and justices' voting records among justices affiliated with the Democratic Party than the Republican Party. So to back up a little bit, I think this perhaps gets to the last point. So what the study doesn't establish is, it's sort of a question it leaves open, is are justices following money, which is to say, are they behaving in a politically strategic way, consciously or unconsciously, in an attempt to attract money or at least to avoid creating an incentive for money to flow to their opponents, or is money following justices? In other words, is there a subset of judges who have an ideology that is reliably pro-business, and business groups just send their money to those justices to get them elected and keep electing them? The study does, we were not able to get into that question. And I suspect, although we don't know, that both of those, that explains this Democratic-Republican split that we were talking about. That in the case of Republican justices, it may be the case that they have or at least a number of them have a reliable pro-business ideology that causes business groups to support them, whereas a justice affiliated with the Democratic Party who might not naturally be attractive to business groups as a target of contributions, if that justice wants to, quote, be in play politically, they're going to have to be some votes there to back that up. And again, the study does not claim that any specific justice, or in fact any justice, is sitting there consciously making these kind of political calculations, but it could be the case that unconsciously, as people deal with complicated issues, there are all kinds of factors in play, that there might be this sort of subconscious tug on them that pulls them in a certain direction. So that's some of the empirical data that's out there in addition to the discussion we've had earlier. Now, so I think everything that's been said to this point has been in a certain direction that having large amounts of money in politics in judicial elections is at best problematic and perhaps awful. But
can I say one small thing about that?
Yeah.
There is a very small glimmer on the other side, and that is the year before Citizens United, the Supreme Court ruled in a case involving a man who had a case before the West Virginia Supreme Court that giving $3.5 million to one of the justices while the case was pending in his election was even too much for the Supreme Court, and they said due process was violated in that case, and they set the case back. The problem is, there were a whole bunch of cases beforehand that they didn't take. The court emphasized, Justice Kennedy writing both for this and in Citizens United, that this was an extraordinary case and suggesting this was an extraordinary remedy. And so you can't look at the due process clause to bail you out. On the other hand, there's nothing that prevents state Supreme Courts, at least in theory, from drawing tighter recusal rules. Unfortunately, they're written by the judges who would have to recuse themselves, who have to stand for elections and not get money. So there's a problem there, but that doesn't mean that active groups like ACS and others can't try to work to get recusal rules that are a lot better and stronger, and among other things require judges to explain why they don't recuse themselves as well as why they do, as a means of having some control and putting pressure on judges to explain why they get large sums of money and they should be voting in the case, whether it's, by the way, a party or an amicus. So the Chamber of Commerce, for example, does a lot of spending. They are rarely a party in the case, but of course their members are parties in these cases, either directly or indirectly. And so for all those reasons, the rules have to be broadly written to try to capture those kind of indirect attempts to influence outcomes. On the other hand, somebody's got to give money to these judicial elections, and the only people who do it are people who are interested in them, which is, of course, the whole problem. The only thing you can say for certain is that judicial elections aren't going away, even though people have no idea why they want to elect judges or what they're voting for or anything about any of the candidates. They want to be able to elect somebody. And every effort to change this in most state constitutions has been uniformly unsuccessful. And so that is not a fruitful avenue if you're trying to deal with this problem, to try to get the states to change it, because it isn't going to happen, at least not for a long time.
Well, thank you, Alan. And that, I think, brings us to a natural question here. And the people, so as we've said, there are things you can point out that would suggest that money in politics are problematic in the judicial selection context, but there certainly are people who are of a different view. And one of the arguments they make is that, and I think one of the contexts in which that argument comes up is, as Alan said, when people try to change state constitutions to take elections out of the process. An argument that gets made is elections are a great means of holding judges accountable to the citizens. And that without the disciplining function that elections play, judges would be completely unaccountable. So, I mean, Bert is the head of an organization that advocates for fair and impartial courts. How do you respond to that argument?
Sure, and let me just say first, as a housekeeping matter, I believe we now do have copies of this report for everybody. You may want them with the same files where the other materials are, if I'm not mistaken. So we hope everybody will take them. As you said, I think a lot of this would be good, valuable fuel for papers, laws, etc. So it's actually really important to bring up accountability here, because in these discussions where we talk on and on about what's going on with the independence of the courts, We need to both intellectually and I think just in a practical manner acknowledge that accountability has to be rather central to this conversation. And in fact, for those of us who go to law school, accountability is often something we kind of set aside and really don't have to talk about when it comes to the courts because it's different. And we know how we want elected officials to be accountable generally. We want legislators and governors and presidents to make promises and to keep promises. I will cut your taxes, I will increase your health care, you hold me to it. That's most of the discussion that goes on around what's supposed to happen in politics and why it may be going wrong. And yet, of course, we give the judiciary a different job. They're designed to be independent, and yet, even though that's part of our Constitution, and that independence is broadly supported by American people, those same American people want both. They want independence and accountability. And so from a practical standpoint, if we do nothing to talk about independence, we're not going to get very far because people will be suspicious. And yet, how do you talk about accountability? What does it mean? I mean, a judicial election is complicated on a good day for reasons you've now sort of heard. What does it mean to vote in a judicial election? What are you voting for? How are you holding a judge accountable if you're using an election system? And I guess I would suggest a couple things. One, I think there's an area where probably everybody would agree, no matter what side you're on, that judicial elections can serve a good function, which is if a judge so clearly is entwined in clear-cut ethical problems or violations, which is sort of a basic moral unfitness to be on the bench. And we've seen that happen in elections where otherwise judges are retained, the voters will actually pick out those judges and send them home. You could intellectually make a case that there may be actual decisions on the bench. As much as we all worry that decisions are being affected, there might be cases we could think of where they so clearly get to someone's actual, just simple unfitness to be on the bench that they just shouldn't be retained, and it's the voter's job to let go. And, you know, if someone sat around just constantly writing decisions saying that Brown v. Board was wrong to decide or Roe v. Wade, I'm not going to enforce it, or you can think of your own extreme example. My suggestion is that they're out there and that we can intellectually probably come to agreement on them. However, the challenge is that's not what happened. That is not what's happening here. It's not about picking up these cases. As you've seen from the ads, this will always be made. This charge will always be made against anybody running a judicial election that you're so soft on crime that you ought to be out of office, and that you just should be on there. And so it won't really matter what your decisions are. The pressure is going to come either way. And essentially, the way we look at it is that you have to think about accountability boiling down to a fairly simple question. It's not so much these other categories I was talking about, it's who you're accountable to, or what are you accountable to. That has a clarifying effect. Are you going to be in a system that promotes you being accountable to the law and the Constitution, which is the job of a judge in our constitutional system? Or are you going to be accountable to partisans and special interests? And if elections serve the former purpose, in addition to us providing an outlet for other accountability tools, that's fine. If they're not, if they instead are turning into vehicles for interest group pressure and political pressure to have their way to bully judges to make decisions they otherwise would not make, then I think there is a failure, and that balance that we all want between independence and accountability goes out of balance. And essentially, when you think about this definition, you can very clearly see that how accountability itself is being abused by people who want to have their way in the judicial system. So you see the money pouring in because they want judges to be accountable to the money. They want them to make decisions based on that. You see the crime ads being run, and therefore the correlations, and the Center for American Progress is studying. There's somebody here, there, you know, and we've seen other studies showing that as election time nears, judges start getting tougher up front. It's a different level of justice sometimes if you're a criminal defendant, depending on whether the election is approaching or not. That's a form of accountability that I don't think many people would agree with. And then in addition, there is what we call an outrage industry that's arisen around the courts. Courts, of course, are supposed to be in controversy. That's part of their job. And by the way, they don't always get it right. They should be yelled at, and feet should be held to the fire, at least in figurative terms. However, there is, you know, and in American history, I should add, we've gone through cycles where the courts have been more or less popular, and there have been, you know, more anger against the courts and more efforts to go after them. And we've been through one recently. I think what's different now is that there's now an industrial apparatus to keep it going no matter what's going on. So you have, under our modern political system, a rise of a network of political consultants for whom it's good money. So they're going to keep the drumbeat going. They're going to say that every single month they're going to hear about some decision that's just the worst ever to raise money. Talk show hosts, be it radio or TV, this is fuel for them. They love judges because they can't fight back. And they do controversial things. They're forced to make a decision on a tough thing. The judge can't appoint a commission and say, you go handle that one, I can't do that one. And we've seen situations where Nancy Grace and Bill O'Reilly have picked out the worst judge in the world And here's this awful case, and get the drumbeat going. We sing 2 states, Ohio and Vermont, where as a result of their campaigns after an individual judge, state legislators filed impeachment articles against those state judges, just because of the pressure they were then hearing constituents who were watching these TV shows. And then finally, politicians. It's not new for politicians to go after the court. On the other hand, there's more of an incentive now if you think there's a payoff to go after them. So that's, in the end, that's my answer to accountability. Is, you can discuss accountability in terms of Aristotle and Hamilton. My suggestion would be you think about, Willie Horton, super PACs. That's what's really happening with accountability. And that's the definition you have to use when you're trying to get that balance between defense and accountability.
Well, before we move to audience questions, one other element I'd like to put in the mix. So we talked about merit selection, elections. Of course, if you're going to have elections, there's different ways they can be carried out. Some states use partisan elections, where judges run as part of a ticket, right? And I think most of us probably have a reaction to that, sort of the same as judges who are being put in a position where they have to raise large sums of money or have to engage in either respond to or engage themselves in negative advertising. I mean, there's something that seems a little off about a judge who may have to rule in cases involving the political process or even cases in which political parties appear before them, having a partisan affiliation, running as a Democrat or a Republican. On the other hand, one of the findings from the Justice at Stake study is that contributions seem to have a larger effect in nonpartisan races. Because I think another thing that we've talked about is that these judicial elections tend to be low information races, that the voters don't know much, if anything, about the judges they're voting for or against. And so at least the partisan label gives them, it may be a crude label, but it is at least a useful piece of information. So Alicia, I don't know if you thought about this question and what you would say.
Sure, it's a great question, and I mean, to just add something to the point about partisan labels giving a piece of information. I think on the one hand, I think there's in a lot of circles discomfort with the idea of judicial candidates having a partisan affiliation. A number of judges in both partisan and nonpartisan states have expressed discomfort, and I think that's even perhaps heightened now as we're seeing a growth in polarization, among parties. I think more so than even in recent history. The Democrats and Republicans are even more are even more polarized than they were in the recent past, and so that might take on even increased resonance as a sort of growth in the politicization of these races and concerns about whether judges are really going to be accountable to the law or if they're going to be accountable to sort of partisan interests. On the other hand, there are, I think the Justice at Risk study has is very interesting in that dimension, and I think this point about low voter information is also something that's really important to keep in mind. So, one aspect, so having a partisan label, having an R or a D next to your name is one piece of information. And one other thing that I think is important to think about is, well, what do voters know if they don't know that? Typically, if you're uneducated about a particular race and you're looking at candidates, what do you know? You know their gender, you might know their race. There's some evidence that if people don't have any information at all about candidates, they might turn to information and stereotypes that we would be very uncomfortable being a basis for, decision making in terms of judges. So I think it's a very serious concern whether or not partisan labels is sort of better than the alternative. As an institution, the Brennan Center, we don't take a position on particular forms of judicial selection, so nonpartisan versus partisan, and I personally don't, I think, really have a position either, in that I think it doesn't. I tend to think that it isn't helpful, in part because in many states these systems are here to stay, to focus on any one element of a judicial selection system. I think it makes sense to sort of look at the full panoply of policies that are in place in a particular state. So in a state that has nonpartisan elections, I think it would be particularly important to have strong voter information guides. It might also be particularly important to have something like public financing for judicial elections to address some of the concerns that the Justice at Stake report highlights, so that judges can have at least the option of running competitive races without needing to rely on special interest dollars to run those races, and thereby, perhaps have these influences that the Justice at Stake or Justice at Risk report highlights. It also might be particularly important to have strong recusal rules in those states if we're seeing those dynamics where judges seem to be under particularly high pressure to somehow pay back campaign contributors. So, it's a very complicated question, and as I said, I think the answer is to look at the full set of policy responses that you can bring to bear in any particular state system.
Alan?
Yeah, a couple things. First, do not be fooled by the fact that these are nonpartisan elections. The first place is the candidates can disclose, I was a Republican candidate for governor. Oh, and are you a Republican? I can't possibly say whether I'm a Republican. The second, the parties can and do endorse candidates. And so it's only the most ignorant who don't know what it is. And so I'm not sure you get much by it. Maybe make somebody feel good that they're running nonpartisan races, but probably not going to make much difference. Second, as far as public financing is concerned, in judicial elections, it was tried in Wisconsin. Unfortunately, the legislature didn't vote anywhere near enough money, and on top of that, all of the special interest groups can now make independent expenditures on top of that, and so the result is almost nobody goes into the public financing system because it's unilateral disarmament. The third thing I want to say is, in the District of Columbia, just to prove that we don't always make mistakes here in the district, we have a Judicial Evaluation Commission, which our judges, the local judges here, are appointed by the president. We get to send names to the president through a commission that selects them. After a certain period of time, when the judges have been in office, there is a public process under which the commission, which has to approve people being renominated, sends out evaluations to lawyers and to people who appeared before the judges, asking questions such as, did you get a prompt decision? Was the judge courteous? Did the judge respect the jurors? So forth. Things that are not perfect, but at least give some information. And so they come up with a report. It's not perfect, but at least it provides some basic information, at least with respect to sitting judges. And so we can think about that as one of the tools in the toolbox to try to leaven out some of these adverse influences.
Bert, if you want to make a comment, and then we'd like to get to your question.
Two things really fast. One, with the issue of partisan elections, I'll also sort of suggest it could play out differently depending on the level of court you're looking at. And there's an argument to be made, maybe a Supreme Court race is a bit more sort of policy-oriented, maybe that signal is somehow more appropriate. On the other hand, we've seen in Texas a few cycles in a row where district court judges in Houston and Dallas have just been swept out in large blocks just because they have a particular R&D next to the name, only having to do with the overall big trend that year. These are people who, by all accounts, dozens of decent judges, no matter what court they came from, they were on just because they had next to their name. I will give more of a defense of public financing and mention that Wisconsin had it in existence for about a year or less, and they got repealed immediately. But I think the better laboratory was North Carolina, which had a public financing system for judicial elections for about 10 years, wildly popular with the judges. And as Alan said, the acid test is whether the judges want to get in. You can't make a public financing system mandatory under Buckley v. Vallejo, so you have to make it attractive. And if it's not attractive, they don't play, then it hasn't really done much for you. The judges overwhelmingly found it attractive. The vast majority played, and these were judges from all backgrounds. They liked it. They liked talking to voters instead of donors, and they liked what it did for public confidence in the system. It did get challenged more near the end by extra money that came in the last cycle. On the other hand, it's now become a bit academic there because it's repealed as well by the new majority in North Carolina. There's also a risk with the states that still haven't, other states may consider it, because the Supreme Court case from a couple of years ago, there's questions whether public finance has been kneecapped because of you no longer have the ability to put in trigger money down the road depending on what your opponent rate is. On the other hand, it's not impossible to design a system with the will that would provide enough money to make it attractive. You just have to put it in the front end. Whether states in this fiscal climate will do it or not is a question, but we view it as still on the table.
I agree with that.
Yeah. Your turn.
Yeah, I just wanted to ask, why not throw off the conceit that these judges are actually making decisions not influenced by the parties? Because I think it's ridiculous in the Article 3 system that we don't think that these justices are, or judges in certain courts or in the district courts, are immensely influenced by their own personal affiliation. We know for a fact, based on, I can't remember which justice, but one of the justices in the majority in Bowers explicitly said that if he had known that his court was gay at the time the decision came down, he would not, at least he would have reconsidered his vote in that case. And so I think that when you talk, Professor Morrison mentioned this, and I study this a lot, that local elections do not get a good turnout. And I think that of all of the statewide elections, state Supreme Court judges and justices, do not get very many votes, and it's pathetic on the how many votes. So why not actually get the parties to sort of put their money where their mouth is and realize that these are immensely important parts of our political and judicial system, and rather than kind of be embarrassed by the fact that we have no reason to understand, essentially say, at least for the state Supreme Court, this is the equivalent of when you're giving money to the government. These 7 people are going to be just as important for your state as gubernatorial elections are. And in that case, then maybe we might be able to increase the profile of judicial elections. And while there will be more of a partisan affiliation, we'll also have much higher turnout.
Okay, let's get some reaction. Well, I can start. I'm sure others have points to add. I mean, I think it's a very good question. I guess I would say a couple things. One, in many ways, it's completely fair to say that a lot of things that may go into a judge's background that are different from quote-unquote the law and the Constitution. That can be a very sterile way to put it. And I guess the dividing line I suggest we're focusing on today is all the things that are part of one before you get to the bench. And what I would view as the big test here is there a decision you make on the bench that might be different than the one you would have made, given all that composition you have, knowing that people will come from different backgrounds, ideologies. Is there something that you might do differently because of the pressure around you? And if that's the case, then I think the system's failed. Because that's not what courts are supposed to do. And it is true that more money would give more attention to low turnout races. And I hope at the very least every single person here will now vote in a judicial election that you have on before you. But at the same time, if the effect of that is to increase that pressure and risk changing more decisions in subtle ways, that I don't think that's worth the cost.
Sure. I mean, I agree with Bert's point. I guess my question would, the question you're raising is a really interesting one about kind of having increased party involvement. Is exactly, what information would those parties be conveying? What pressures, institutional pressures, might these parties be creating? I think what we've seen, for example, from some of the ads is that you're not seeing a real robust marketplace of ideas and debates around the issue. An ability to really kind of unpack what a judge stands for. And so, I mean, my reaction when I hear your proposal is just that I'm not convinced that increased party involvement, increased party spending is going to sort of lead to a more positive, more transparent, more robust conversation about kind of what judges do and the information that voters have available about their positions on disputed issues of the day. I mean, my concern is that it would just sort of be more of what we've already been seeing, which is not a particularly not a robust debate, something that just feels very politicized and not in a good way, and creating at least a public perception that judges are not kind of judging based on the cases before them, but on sort of be responding to special interest pressures.
I'm sorry, but there's absolutely a perception across the entire United States that judges do not decide cases based on what the facts that they cite before them. There are 9 guys sitting over on First Street where these pretty much prove that on a daily basis. Whether or not they actually do that for every case they come before the Supreme Court strong perception that the judges in the high courts are acting like the U.S. Supreme Court, and they're letting personal political views influence how they vote. And I guess what I'd say about the robust conversations, you're right, and you will get access to that. But right now, there's no incentive on the part of, say, the Democrats, who are very strongly supportive of the private law, to essentially say, okay, we will, when we're on the bench, we will be very, we will be extremely friendly towards standing issues. We will be friendly towards, whether or not, we're going to read closely into, labor relations, or torts or anything like that. Right now, there's no incentive for them to care about that at all because, the national legislature really doesn't care about judicial elections.
Well, I guess we have states that have partisan races right now, and we're not seeing those sorts of conversations. I mean, I guess what I understand the concern, but I'm not convinced that that introducing partisan affiliation into these races is the solution, and that the states that have that don't seem to be having the sorts of conversations that you're talking about.
Alan, did you want to here?
Well, one of the things to think about is what is the length of the judge's tenure in office. They're less likely to worry about re-election if they're in for a long period of time, and one vote here and there won't be seen as often. On the other hand, if people talk about accountability, how can you let somebody be there for 14 years when they're unaccountable for 14 years? So, that's just one of those trade-offs that has to be made. But surely the Texas judges who are serving for only 4 years, that can't be the right number. I don't know what the right number is, but that surely, it allows too much turn on daily decisions that can easily be distorted.
Yeah, here and then, sorry, here.
This is a two-part question. Do you think that there are people out there who are experts on the law and aren't partisan ideologues and really are willing and able to decide cases merely on the law, sort of an objective interpretation of the law and the facts of the case? And it seems to me that the diversity of human opinion and human experience being as large as it is, there must be people out there who fit that description. And so why isn't there some system for finding non-partisan, truly independent experts on the law and having them be judges? And the second part of the two-part question is, if not, why not? I mean, why is the world we live in really so partisan that there's really no such fit as an expert on the law who's willing and able to decide merely on the basis of the facts of the case and the interpretation of the law?
I fear that the law is too indeterminate to do that. That it's just there are lots of 5-4 decisions in the Supreme Court every year, and some of them have nothing to do with partisan alignments. They just have difference of opinions, same with state Supreme Courts. I wish there were metronomes who could decide these cases, just put in the facts and grind out the law. I had an algorithm for it. I disagree with some of my colleagues here about things all the time, and it's not because of funny politics. It's just because we think differently about certain things, and not always the same things to the same people. So, when Chief Justice Roberts was before the Senate, he said he was just an umpire, just calling balls and strikes. Nobody who's ever studied law thinks that deciding cases like calling balls and strikes. Not that the umpires do such a great job themselves, but it's not. It's hard. I've been doing some moot courts lately in cases, and some of these cases are really hard. It's just I don't care about the case. So I just wanted to think about what the right outcome is, and I just don't know what the right outcome is. So I have some sympathy for them, and sometimes at least you can sort of, with your political and a lowercase p word, not in a Democrat or Republican, but your general worldview will say, well, it's a close case. I think in general this needs to be, the society would be better off if we did this or more of this or more of that. I don't know. I just, maybe others disagree.
Well, hopefully one more question. We want to get you out of here into class on time.
I think you can also.
My class is 4 o'clock.
I think you can also answer the question through the lens of fairness. And we can never get perfect fairness. We all know people who are more or less ideological, and within those groups, more or less fair, who we want, therefore, thinking about cases if they were a judge, let's say. And I think maybe the main point today is that it's always been the issue that there'll be people on the bench probably across the spectrum as to how more or less fair they are. We want a system that's more fair. What's happening in the last dozen years is pressuring it to be less fair. It will never be perfectly fair. That is literally impossible.
One last question.
Yeah, so I mean, you guys mentioned a lot today that one of the problems is that the public doesn't have enough information. And so I was just wondering what, in a, I guess, normative sense, in your opinion, what type of information do you think is important to the voter? What should they want to know? Is it based on, you know, literal cases that judge has decided previously? Should they be looking at a judge's general, you know, legal philosophy? You know, I mean, how much does the public know about, you know, well, I denied a case because I was supposed to review it de novo, and you know, the trial judge made this particular error, although, of course, I still thought the guy was guilty, right? I mean, how much intricacy could the public really get into in understanding those types of complicated issues?
Great question.
Sure. Well, so I mean, I think there's a couple of categories of information. I think you'd want to have information just about the judge's, you know, background and experience. You know, so where, you know, how long have they been a lawyer? You know, what did they practice if they were a judge for how long? You know, just sort of background about their qualifications, so to speak. And then I think it is appropriate to be looking at judges, you know, judges' decisions. I think the ideal would be to have, you know, sort of an ABA type organization, so sort of nonpartisan organization that can, you know, bring information about, you know, not the basically about the kind of quality of the judges, you know, reasoning. They're applying, you know, law to facts, and you know, so not you know, not focusing on, you know, one or two hot button issues or hot button cases, and certainly not distorting decisions that judges made, but basically providing information that a layperson could be able to grasp about, you know, is this a judge that, you know, does a good job of, you know, applying the law, and, you know, bringing in a kind of nonpartisan organization to do that kind of analysis.
So, yeah, it's always great to have your former students ask really good questions. Thank you. The question really asks, why should we have elections to begin with? That's the underlying current of your question. And the answer is because people want to have them elections. And qualifications will only get you so far. And what do you do about comparing a person who's been a judge with persons who are not judges? That is, one of the things about this announce rule in the Republican Party case that I dislike so much is that there was an exception for judges who wrote opinions. And so they could be writing opinions all during the campaign, which would tell you much more about their views than anything that anybody could say in a debate. And those were perfectly okay, because you couldn't tell the judge not to write opinions during the time. And so it's very hard to compare these different aspects. Because of you don't know who's running and what the issues are going to be. So I think that's the point. You've got your question raises this question about what's wrong with the system more than how are we supposed to deal with it.
Bert, just very quickly, and then
I'll just add that actually there are a number of voter guide programs out there, often done by bar associations or other organizations that attempt to get to the issue of qualities and both you know, temperament decisions, fairness, etc. When they're done at their best, they're done by peers, people around the judges, other judges themselves, sometimes scholars, the lawyers, court employees. The challenge is getting them you know, really injected into the bloodstream of election campaign. And we've all seen reasons why they might get ignored, but this is one of the reforms out there. Again, more people simply voted these things. The turnout crisis is real. Because the turnout's so low and a lot of people show up for elections and stop when they get to the judges, that's the vacuum that's left for the interest groups. So if you do nothing else and vote in these elections and get 10 other people to just pick their favorite judge and vote for them, that will help.
Well, thanks to our speakers.